mentioned that he has also been in very high-ranking positions in the Italian government, the peak of which might be mentioned that he has served as Minister for Public Administration and Simplification. So, Signor Presidente, per favore.
Thank you, Mr. Chairman. And let me too warmly thank the Supreme Court of Ireland, the Presidency and the General Secretariat of ACA for organizing this seminar and hosting us in this beautiful castle. I've been asked to focus my speech on organization and functioning of the plenary assembly, what we call adunanza plenaria, that is the special jurisdiction body of the Italian Council of State in charge of ensuring the respect of what we call monophylactic principle in the administrative system. That is, this word comes from Greek, ancient Greek, of course, and we mean by that the function to guarantee uniformity and stability of case law. Its current composition of 13 judges, including the President of Council of State, dates back to 1982, even though the plenary assembly dates back to the beginning of the 20th century. First of all, I think it should be pointed out that despite the lack of rules on the binding value of the President, stare decisis, in our system, administrative judges have given a great contribution to the creation, as we say, of the administrative law in Italy. The plenary assembly itself has provided a solid basis for the administrative procedure and the administrative proceeding before courts, with many decisions regulating the relations between citizens and public power, drawing rules to public authorities, ensuring protection by the courts to situations not mainly regulated by law at all. Nowadays, on one hand, this creative phase is receding as the jurisprudential principles have increasingly been codified, they've become law. But on the other hand, the role of case law is still crucial in our legal system because of the absence, not because of the absence of normative ruling, but for its overwhelming and contradictory being. Nevertheless, the importance of case law in the evolution of administrative law as side effect could take the risk of having less predictable judgments. In fact, the absence of codified rules, first, the matter that the public power itself is unpredictable, since the identification of the public interest to be pursued is a sort of work in progress. These two factors contribute to the unpredictability of courts' judgments. And this is a problem, because case law stability and decisions predictability are important values nowadays, being related to general principles such as legal certainty or protection of legitimate expectations or predictability for citizens and companies of the consequences of their behavior. In this general framework, Article 99 of our code has codified the non-prophylactic function of the plenary assembly, strengthening its role of solving conflicts that have arisen or could arise among the jurisdictional sections of Council of State. This article established the binding value of the decisions of the plenary assembly. But let's briefly analyze how this mechanism works. The plenary assembly decisions have binding value, we say. That is to say, they set a principle of law that must be applied in all similar cases. Therefore, all judges shall interpret the law according to the principle set by the plenary in relation to a specific case. But what does binding value exactly mean? It does not mean, indeed, that all the sections of the Council must comply with the plenary assembly rulings. It means instead that if one section does not agree with the principles stated by the plenary, it cannot judge in disagreement with it, but it must once again refer the matter to the plenary assembly to solicit a change in jurisprudence. In other words, the revirement of the decision of the plenary assembly is allowed, but only to the plenary assembly itself. What is the procedure for submitting a case before the plenary assembly? Well, the power of referring a question is given to a section or to the president of the Council of State. The section may refer a question if it detects that the matter, the point of law, has brought about or might bring about conflicts with case law. But, you see, the referral is mandatory if the section considers not to share a principle of law enunciated by the plenary. Secondly, the President of the Council of State, at the request of the parties or ex officio, may refer any application to solve broad issues of particular importance or to settle disagreements within case law. So, as you see, the parties cannot appeal directly to the plenary assembly, nor the question may be referred by the courts of first instance. Moving on to the decision phase, it should be pointed out that until the Code of Administrative Procedure entered into force, the conclusion of the referral procedure was the final decision of the entire dispute. Currently, the Code provides 4 different outcomes of the referral. First, the plenary assembly may return the case to the section if it decides not to decide, considering appropriate not stating a binding principle of law at the moment, for example, because a debate between sections could be still needed. Secondly, the plenary assembly decides to state the principle of law, but returns the judgment to the referring section for the rest. Thirdly, the plenary assembly decides the entire dispute. And four, the plenary assembly, even though declares unacceptable an application or the extinction of the judgment must be declared, the plenary assembly can still state the legal principle in the interest of law if it considers that the matter is of particular importance, with no effect at all on the dispute, but with a general statement. All these mentioned ways of concluding the proceedings before the plenary are aimed at, as you see, at strengthening its nomophylactic role, in particular with the enunciation of the principle in the interest of law. Well, I think that in this pendulum between the need for legal certainty and predictability on one hand, and on the other the necessity of evolutionary interpretation of law, the mechanism of the referral I've just described has created, I think, a balanced situation. This solution, in fact, tends to ensure stability, supporting predictability of any decision relating to similar cases, but preventing the jurisprudence from getting stale, because it is always possible for that principle of law to be overruled by the plenary assembly itself. Nevertheless, we say that Article 99 does not introduce the principle of stare decisis into the Italian legal system. This would conflict, in our view, first with Article 101 of our Constitution that submits the judge exclusively to the law and not to another judge decision. Secondly, with the principle of separation of powers, according to which law is placed only by Parliament. Nevertheless, this mechanism enriches the system with a new source of law, though a cultural one, based no longer solely on the authoritativeness and persuasive capacity of the Supreme Court, but on a specific positive legal restriction. In the end, let's examine briefly the issue of the possible interference between the described role of the plenary assembly and the European Court of Justice. To this regard, we must recall two decisions of the European Court of Justice, that is the Puligenica decision, and before that the Interredil case, according to which no national court may be bound by the ruling of a higher national court if these rulings are at variance with the European Union law as interpreted by the Court of Justice. Well, reaffirming the prevalence of European law is probably obvious. The consequence of this reaffirmation is more questionable. The European Court of Justice states that a single section which is unwilling to comply with the plenary assembly's decision can directly refer the question to the European Court without previously involving the plenary at national level. Even though this instance at national level has a binding value, as I said before. In this respect, in my opinion, some doubts arise in relation to the principle of member states' procedural autonomy, because this jurisprudence of the European Court actually weakens the stabilizing role entrusted to a body as the plenary assembly, and also to the joint sections of the Court of Cassation in the civil law system. Conclusion, I believe that the non-phylactic principle, despite its considerable complexity in systems which do not know study decisions, works as a counterpart to the unpredictability of judicial decisions. In the lack of this, we must consider that the principle of equality would be weakened, as well as the trust that the citizens rely on the consequence of their behavior if respectful of the law. Thank you.